Great. Thanks everybody for joining. We're just letting you into the waiting room right now. And from the waiting room. So thank you everybody for joining. I'm Jen Walling from the Illinois Environmental Council. So thank you for joining our IEC for our Lunch and Learn series. We're hoping these sessions will help keep our community connected during this difficult time, and we've made them publicly available. So this one, in addition to the public being able to join, we are going to record it and put it on YouTube so anybody can watch it later. Just a little bit of info about IEC. We're founded in 1975 by a group of dedicated grassroots environmentalists. And we've led issue advocacy campaigns by allowing environmental organizations to pool their resources and creating a higher profile for environmental issues. Today, IEC represents more than 90 environmental and community organizations and many individual members from throughout Illinois. If you're not already a member of IEC and are able to give, please consider joining today by using the link in the chat box. My name is Jen Walling, and I'm the Executive Director of IEC. I've been the Executive Director for over 9 years now. And, you know, as you can see, my background here is the state capitol. Normally we'd be in Springfield this time of year trying to negotiate bills, and this is a whole new world. So we thought it would be really important to discuss environmental issues and educate people during this time where folks are at home. So again, thanks for joining us. A few housekeeping items. All of the attendees are going to be muted by default so that everybody can enjoy what's going on. If you joined via Zoom, you can use the chat function to ask questions, add comments, or provide resources. We've had some really robust chats during some of these. Time permitting, we can take live questions at the end of the session. And so you can use the raise hand feature if we do take live questions, or raise hand feature, which is in Zoom if you're using the webinar. If you're on the phone, you can just press *6 to be unmuted on the phone. But we want everybody to stay muted during this presentation. So we have 2 speakers today that I'm really excited about. Oh, and just one, for those of you who are on to get continuing legal education credit through the ARDC, in just a moment, I'm going to put a link in the chat box, and it's a link to a Google form. You'll have to go fill it out and put your name, ARDC number, and email address, and I will email you a certificate within the next week that indicates that you got the credit. I'm just going to put that in there after I stop talking, but you are eligible for 1 hour of free CLE credit for sitting through this, but you'll have to sign in to the document that I put in the chat box shortly. If you are on the phone and don't have access to that chat box, just send me an email or reply to the note that you got with this information asking for the link, and we'll send it as soon as we can. So with that being said, I'm really excited about this really hot topic today. The National Environmental Protection Act, really relevant because of the role of NEPA in Earth Day, which we're about to celebrate the 50th anniversary of, just being a really important federal law. So we have 2 very talented attorneys on today. One is Stacy Meyers, who is at Openlands, and the other is Rachel Granneman, who is at Environmental Law and Policy Center. Stacy is going to review a lot of how NEPA has worked up until today for the last 50 years, and Rachel is going to talk about the rollbacks and give you a little bit more information about what you can do. So extremely important topic. We're so lucky to have such great presenters here. If you have any questions, type them in the chat box. We'll get to live questions at the end. Maybe we do have a lot of content today. But I'm going to put that CLE link into the chat box in a minute and give Stacy the reins. So go ahead, Stacy. Thank you so much for joining us.
Thank you. I'm going to share the presentation now. Okay. So today I'm going to be going through about an hour and a half of content in about 25 minutes. So a lot of what you're going to see is available in the PDF for further details. So my apologies for skimming through this so quickly, but there's a lot of ground to cover. So my name is Stacy Meyers. I'm Senior Counsel with Openlands. I'm going to be discussing in the first part of our presentation, basically the fundamentals of the National Environmental Policy Act. So the purpose of NEPA is threefold. It's to encourage productive and enjoyable harmony between man and his environment, prevent or eliminate damage to the environment and biosphere, and stimulate the health and welfare of man. The environmental view is the key portion under the National Environmental Policy Act, and it's a review of any major federal action that significantly affects the human environment. So what the heck is this? A major federal action is basically federal funding, approval, or licensing of a project, manifest indicia of control. Federal funding can not only be basically a federal statute, but can be federal money that flows down through the states and local government for certain infrastructure projects. The human environment is quite vast. It's a wide net that includes environmental, cultural, agricultural, historic, and other considerations. So normally we consider road projects to be the primary kind of infrastructure reviewed under the National Environmental Policy Act, but it's much broader than that. It includes rail projects, airports, intermodals, and other kinds of infrastructure with a federal hook. There are three different levels of environmental review under NEPA. You have categorical exclusions, environmental assessments, and environmental impact statements. Categorical exclusions, known as CADEXs, are generally lists by agencies of activities that they know will not have a significant impact. An environmental assessment is supposed to be a truncated review to determine whether or not there may be an environmental impact that needs to be studied under an environmental impact statement. An environmental impact statement, otherwise known as an EIS, is a full-blown NEPA study of all of the alternatives and environmental consequences of a particular action. So, whereas environmental impact statements should be the go-to document for a major infrastructure project, what we are now seeing is many projects are basically just undergoing an environmental assessment review. And we'll talk a little bit about, as we move through this, why that's not exactly so great for us from a public process perspective or from a full review process. So NEPA is a procedural statute, but its power is daylighting and bringing the public into substantive review of many different kinds of statutes. We're going to touch upon some of these statutes and other review processes in the presentation. Under NEPA, agencies must, first and foremost, define the purpose and goals of a proposed project so it can consider reasonable alternatives. It's supposed to rigorously explore and objectively evaluate all reasonable alternatives for achieving that purpose and goal. It should define the affected environment and take a hard look at the environmental, social, and cultural consequences of the alternatives. So in that process, agencies must assess ways to avoid, minimize harm, or enhance the quality of life of the human environment. So what does the NEPA process usually look like? For an environmental impact statement or an environmental assessment, you would first have a notice of intent filed in the Federal Register. The process would then move to scoping the project. If you have wetlands or jurisdictional waters involved in the infrastructure project, you generally would have a merger of the NEPA review and the 404 permitting process. We'll discuss what Section 4F means, but that would be an open study as well as an endangered species consult and biological opinion. All of those would be wrapped into a draft environmental impact statement, which would culminate in a final environmental impact statement and record of decision. There would be a finding of whether or not there is a significant impact, or what's called a FONSI. Generally, you have at the end a finding of no significant impact, which all of this would be approved by the Federal Highway Administration or federal agency in charge to authorize the project to move forward for funding and for construction. So scoping is the first contact with the public. It sets the boundaries for the study. It's arguably one of the most important parts of the NEPA process because it sets everything up for success or failure. During scoping, you define the project and study area, identify the affected public and agency concerns, assemble cooperating agencies, set the process and schedule for public and agency involvement in the permit and the environmental review process. And generally scoping will set out select issues and alternatives to study in detail. So what the heck is purpose and need? It's basically at the foundation or the baseline for the study. It can be boiled down to how I was taught, 6 + 2 = 8. Simply put, you first look at the existing condition. This is otherwise known as the no action alternative or baseline and the effective environment. This is all of the other road or rail or projects that are going on in the area that really are relevant to the problem that the agency is trying to solve. So for instance, if you have the potential for a road, you would also look at transit and other projects, road projects that you believe will likely go forward within the next 30 years. The proposed action, or 2, is the purpose, or a statement of goals and objectives that the agency action will fulfill. Together, 6 + 2, the existing condition and proposed action, equal the need. It is a noun. It's rarely a noun, but it should be a noun, and it's the underlying requirement or condition. So the purpose and need is critical to get right because it guides the range and selection of alternatives. An example of this is a reliable and adequate water supply or supply of potable water to a remote location. Now, what we see happen sometimes, and what absolutely cannot happen, is reverse engineering. So agencies make an arbitrary and capricious decision if they purposefully narrow the purpose and need to constrain alternatives. You can't have it because you want it. You have to need it for a particular reason, and it has to make sense according to what else is going on. Defining the study area is really important in that it can narrow the proposed alternatives that would be reasonable to the project. For instance, this is the Ileana study area. If you noticed, up and to the right, there's I-80. I-80 was left out of the study area, even though it carries 180,000 cars and trucks per day. Improvements to I-80 were important to evaluating whether or not Ileana was needed. Calculating an accurate baseline is part of purpose and need. It's also instrumental in the environmental impact statement in really looking at whether alternatives will meet the purpose and needs set out by the agency. The Chicago Metropolitan Agency for Planning does a wonderful job calculating out populations and households and employment projections out for 30 to 40 years. So these should be underlying figures as to calculating out whether or not the roads are necessary to move people from where they live and work to where they need to be. Scoping, you have to look at all of the reasonable alternatives, which means the ceremonial drawing of the lines. Whether it's on a computer or on a piece of paper, you generally will have everybody convene all different interests in where there may be alternatives to resolve the purpose and need. Your paper should at least look like this once it's refined, not this. So NEPA prohibits agencies from ramming through a project before first weighing the pros and cons of alternatives. The alternatives analysis, which is known as the heart of the NEPA process, is the rigorous exploration and objective evaluation of all reasonable alternatives in an environmental impact statement. And the court takes this very seriously and has held, in this US Supreme Court case that's often cited to, the existence of a viable but unexamined alternative renders an environmental impact statement inadequate. Of note, when I was telling you about the different layers of review, the different levels, an environmental assessment can only involve it can legitimately only be constrained to a baseline alternative and a preferred alternative. This shows how an environmental impact statement can be really truncated compared to an EIS and constrain other reasonable alternatives that otherwise can be considered during the review. So once you come up with your range of alternatives, the courts, the law as it stands, requires taking a hard look at all of the environmental consequences of those actions. You have to look at both the environmental consequences of the baseline alternative and then all of the other reasonable alternatives in play. So you're supposed to discuss the direct, indirect, and cumulative impacts of a proposed action. And in sum, you're supposed to evaluate possible conflicts between proposed actions and the objectives of federal, regional, state, and local land use plans, policies, and controls of the areas of concern. Again, this is pretty broad. So taking a hard look at environmental consequences should neither be cursory, or it should not sweep negative evidence under the rug. So it has to assess the environmental impact of proposed agency actions rather than sort of justifying decisions that it's already made. The ends do not justify the means. So direct impacts are caused by an action and occur at the same time and place. This is basically the bulk of what we would see as environmental impacts, degrading waters, worsening 303D impairments to listed waterways, destroying wetlands, fragmenting forests, increasing noise, air, and light pollution, lowering air quality, especially in ozone non-attainment areas, ruining wildlife habitat, and harming rare, threatened, and endangered species. So, in conducting a true review and assessment, taking a hard look at environmental impacts, it is imperative that information is of high quality and integrity. I wish I did not need this slide. Here are 3 statements that I have seen that really explain why it's so necessary that we comb through these environmental studies to ensure that the best information is being used and evaluated as intended. Street lighting could be a conservation benefit because it will drive away federally threatened northern long-eared bats that otherwise could be struck and killed by vehicles. That was in an EIS. Intolerant fish in high-quality streams will not be impacted by 81 stream crossings because fish are, quote, mobile and will, quote, likely avoid highway construction. Highway noise, air quality, and lighting from the Ileana Tollway on Midewin National Tallgrass Prairie are not expected to adversely affect its globally imperiled grassland bird habitat, some of the last in the world, since it is commonly believed that relatively mobile birds and wildlife would move away from such sources. So I have seen mussels sprint out of the way of pylons. I have seen trees that somehow can jump behind bushes to avoid salt, and all sorts of sundry wildlife that is unique to the world in these studies. Now, whereas that may seem humorous, the impact is severe because we are looking at some of these infrastructure projects at some pretty heinous damage that would occur with some of the alternatives in play. This is just an example of what was in the path directly of the Prairie Parkway, which was neither a prairie nor a parkway. So when looking at direct impacts, here's where some of the substantive laws come into play. Compliance with the Clean Water Act as part of the NEPA review. 303D of the Clean Water Act requires states to adopt water quality standards that at least include dedicated uses for water bodies within their jurisdiction, water quality criteria necessary to protect the most sensitive of those uses, and anti-degradation. So we're talking about recreational uses, aquatic life uses, potable water supply, etc. Impaired waters on the 303D list that's held by the Environmental Protection Agency is important in that when seeking a Section 404 or National Pollutant Discharge, my apologies, Elimination Systems permit, or a water permit, water pollution permit, a project cannot contribute to an impairment. So water bodies that do not meet water quality standards are identified and listed as impaired for pollutants such as nutrients and bacteria. So the bottom line here is if we have an impairment in a waterway, the project is supposed to show what those impairments are and how it won't make those impairments worse. Because under Section DOD, that is not allowed. Antidegradation is designed to maintain and protect existing water uses and a level of water quality to protect those uses, high quality waters, and outstanding resource waters in our state. So anti-degradation is often thought of as protecting the best of the best. It protects a lot more than that. You can't backslide, and it's an important part of the NEPA analysis. So this not only involves basically what it looks like when the project's done, but from construction through what kind of infrastructure you place and how it will impact that particular kind of structure, the waters involved, as well as how it will be maintained and operated and what kind of pollutant loading is expected during the normal course of operation of that road or rail or whatever else kind of infrastructure would be. So indirect impacts are caused by an action and are later in time or farther removed in distance, but are still reasonably foreseeable. This is the second kind of impact NEPA is required to review. Foreseeable impacts are supposed to evaluate possibilities in light of current and contemplated plans and produce an informed estimate of environmental consequences. So, for instance, induced growth, which is growth-inducing effects and other effects related to induced changes in patterns of land use, population density or growth rate, and related effects on air and water and other natural systems, including ecosystems. We know from numerous studies, as well as many of our work, that urbanization can have a profound influence on the diversity and integrity of biota within certain ecosystems. Simply put, when you pay that, it can affect the quality of what remains. So this is basically where considering land use planning comes into play, and it is a critical and integral part of planning for the best alternatives that complements rather than sacrifices our natural, agricultural, and historic heritage. Agencies must explain how they would reconcile the proposed action with land use plans. They don't necessarily have to make the two mesh, but they have to explain whether or not they're in sync and why. So this is also important in that this is where you consider sustainability and resiliency in addition to with the direct effects, how we are going to live and grow in a way that we flood less, that we grow responsibly. Cumulative impacts. The third kind of impact is the combined incremental effect of human activity or death by 1,000 cuts. The incremental environmental impact of actions when added to other past, present, and reasonably foreseeable future actions. It does not matter what agency or person undertakes the other actions. So if you have a roadway, a railway, and a wastewater treatment plant that are going to expand or be basically put in a certain area, you have to consider the combined effect of all three on the project area. So NEPA and 404 is complicated, but I'm going to try to simplify this. You can have a huge infrastructure project like the Ileana Tollway that would affect wetlands and require a 404 permit, and that would have to be folded into a NEPA review process. Or you can have a permittee request a permit, or an applicant request a permit from the Army Corps under Section 404 to basically fill certain wetlands, and then that may require an environmental assessment or environmental impact statement, likely an environmental assessment, in order to have the Corps approve of that permit. So issuing permits under Section 404 qualifies as a major federal action. This is one of the heaviest substantive laws that falls under NEPA. Identifying the project purpose and need under NEPA has a significant effect on the 404 process. So the Army Corps issues permits to regulate discharge of dredged or fill material into waters of the United States, including wetlands. This unfortunately has been impacted by the recent rollbacks of waters of the United States. What qualifies under that as jurisdictional, this also reduces the reach of Section 404 permits. So for a Section 404 permit, the Corps looks at two things as to whether or not it can issue a permit. It looks at whether there's a practicable alternative to the proposed discharge, which have less of an adverse impact on the aquatic ecosystem. And that is so long as the alternative doesn't have other significant adverse environmental consequences. And it looks at whether jurisdictional waters, or WOTUS, would be significantly degraded. An alternative is practicable if it is available and capable of being done after taking into consideration cost, existing technology, and logistics in light of the overall project purpose. So in looking at whether to grant a 404 permit, the applicant, the petitioner, has to look at, it has to show that it has taken steps to avoid impacts to wetlands, streams, or other aquatic resources, minimize or reduce potential impacts of action, and mitigate or compensate for all remaining unavoidable impacts. So the scope of analysis is different when you have a NEPA project that will take wetlands or impact wetlands, not only take wetlands, because there's direct and indirect impacts involved, or whether or not you just have a petition before the Army Corps. Of course, the project, when it has a piece that involves wetlands, will have a much broader scope and jurisdiction under a federal agency like the FHWA. However, there are ways to look at the maximum extent possible to look at the broadest range under the Army Corps. It's generally a narrower jurisdiction. You have to make sure that the Army Corps has sufficient control and responsibility to warrant a federal review, ensure that the project results from or is conditioned upon the permitted activity, and you would look at the permitted activities physical, functional, and whether or not it's physically, functionally, or logically separable from the larger project. If it's an integral part to the project, you may be able to expand out the scope of the review. But the Army Corps is much more confined in what it can review under NEPA. The role of mitigation. So agencies can commit to mitigation and monitoring to avoid, minimize, rectify, reduce, and compensate for potential adverse environmental impacts, such as wetland mitigation, habitat restoration, depressed footprints, sound walls, but it still must evaluate the impacts as part of NEPA. You can't just basically say, don't worry, we've got this, we're going to mitigate for everything so that there is no impacts. You have to say, there is an impact, and this is why it's not going to be significant. Endangered Species Act is another substantive law that falls under the procedural umbrella of NEPA. It protects endangered and threatened species and their habitats by prohibiting the take of listed animals as well as other things, except under federal incidental take permits. So the U.S. Fish and Wildlife Service conducts a Section 107 consult, produces a biological assessment and opinion. This also happens on the state level if there are any state-listed species involved. Section 4F is another substantive law under NEPA. It applies to transportation programs or projects that require the use of publicly owned land, like public parks, recreation areas, wildlife and waterfall refuges, on the national, state, or local level. So if you have a significant forest preserve, it counts. Also, this applies to historic sites on the national, state, or local significance. Now, the FHWA can only approve of a project that uses Section 4F land if there is no prudent or feasible alternative, and the project maximizes all possible planning to reduce harm. And this excludes de minimis impacts. So you don't only have to pave over land in order for it to qualify for Section 4F protections. If a project would constructively use or have proximity impacts that are so severe that the qualifying protected activities, features, or attributes are substantially impaired, it's a problem under Section 4F. National Historic Preservation Act, Section 106, is another substantive provision. Unfortunately, whereas this is really important and it can influence how projects move forward and whether or not they avoid impacts to really important historic structures, it doesn't necessarily prevent damage to those structures. It's still a very important review, in that it can daylight the loss of significant historic and cultural properties.
Stacy, just giving you a heads up that it's 12:30.
Thank you, almost done. So now it's important not only to look under federal hooks, but also state substantive laws like the Illinois Skeletal Remains Act, which protects all unregistered graves and grave artifacts and other things that are over 100 years old. And this protects against all disturbances. So it's important that any EIS evaluates this. Prime farmland and Centennial farms also need to be evaluated under NEPA, looking at land evaluation site assessment scores and registered and qualifying Centennial farms, as well as there being other review concerns that are extremely important as to how a project can have a fundamental influence on a region. Climate change, for instance, is critical to review during the EIS process, during the NEPA process. Groundwater and recharge areas, contaminated sites under CERCLA, and environmental justice issues all need to be considered as part of the environmental review process. I'm going to turn it now to Rachel Granneman. Rachel, I'm going to stop sharing. There you go.
Okay, let me get this started. Okay, can everyone hear me? Yes, excellent. Okay, so good afternoon. I'm Rachel Granneman. I'm a staff attorney with ELPC. And so Stacy just gave a great overview of what NEPA is and how NEPA is supposed to work. And now I'm going to talk a little bit about Trump's proposed rollbacks related to NEPA. So the Council on Environmental Quality, CEQ, is an agency in the Executive Office of the President. And it's an agency that was created by NEPA itself back in 1970. And CEQ's job is basically to help other federal agencies comply with their NEPA requirements. So CEQ issues guidance and regulations to sort of set out what NEPA requires. And the current existing regulations were mostly written back in the 1970s. So CEQ now under President Trump has proposed new regulations back in January. And these new regulations would basically undermine every aspect of the NEPA process. It would take hours to go through every single piece of these proposed rules and all the reasons that it's bad. But I'd like to highlight sort of three broad categories of concerns today. So the first is that the proposed rules would limit the applicability and the scope of NEPA. Secondly, the rules would undermine the integrity of the environmental review process as well as the value of that review. And third, the proposed rules would try to restrict both public input into the process as well as review by courts after the NEPA process has been complete. And a couple of points before we dive in. Lots of people have been talking about NEPA rollbacks. So it's important to understand that this is not a revision to NEPA itself. So NEPA itself is the actual statute, the law passed by Congress. What's being rolled back here are regulations that help agencies know what they have to do to comply with NEPA. However, CEQ's rules flesh out a lot of the requirements about what agencies have to do to comply with NEPA. So they are very important, and they also apply to all federal agencies, which means the implications of this proposed rule are quite broad. So the proposed rules would start by limiting when NEPA applies to an action in the first place. So for example, the rules say that NEPA would not apply to an agency action that is in part non-discretionary. So sometimes agencies are directed by law to take certain actions, to do certain things. So they don't actually have an actual choice. And there it doesn't make as much sense to do a NEPA analysis because they don't actually get to choose what they're doing. However, if an agency does have some discretion in its action, it should have to comply with NEPA so that it has a full understanding of the impacts of what it's doing and is able to make better decisions based on that knowledge. The rule would also allow agencies to essentially decide on their own that they don't have to comply with NEPA, either because it would be inconsistent with congressional intent, whatever that means, or because they can do something else that's essentially as good as or a substitute for the NEPA analysis. So obviously letting agencies sort of just decide on their own whether or not they want to comply with a law seriously undermines the purpose of NEPA. The rule would also limit the types of alternatives that have to be considered when an agency is considering an action. So as Stacy explained, the alternatives analysis is a critical part of the NEPA process. Here the rules say that the agencies can base their purpose and need on the applicant's goals, what the applicant wants to do itself, and the agency's jurisdiction. So for example, if the Illinois Department of Transportation wants to build a new interstate highway and it's getting federal funding from the Federal Highway Administration, that would trigger NEPA because there's federal money at play. And Federal Highway Administration could say, the purpose and need is to build a new highway. And that would be, basically framing the purpose and need exactly to meet what IDOT wants to do, what the Department of Transportation wants to do. A better purpose and need statement that would more fairly reflect the overall goal would say the purpose and need is to improve accessibility, or is to improve transportation options. And that broader purpose and need statement allows the agency to then consider other types of alternatives, like improving public transit, or improving local roadways, or other ways of meeting transportation goals without necessarily saying the only option is to build a highway. The rule also says that instead of, the current rule, I guess, says that agencies have to rigorously explore and objectively evaluate all reasonable options. So this is a pretty stringent requirement that agencies really have to think about different options. Not all ideas are good ideas, and it's important to sort of think about other ways of achieving a goal. So the new rules would strike much of that language and just require agencies to evaluate reasonable alternatives. So this sends a clear message to agencies that they can sort of do a half-hearted review of alternatives, which will almost certainly lead to not as good of decision-making. The third piece of this is that the rule would also limit the types of environmental impacts that an agency has to think about. So Stacy explained that under the existing rules, agencies have to consider not only direct impacts, but also think about indirect impacts and cumulative impacts. So impacts that are a little bit more downstream and how the product will impact resources in the environment when combined with other projects or other infrastructure that is being built or has been built or will be built in that same area. So the proposed rule would let agencies essentially just stop considering indirect and cumulative impacts. This is especially problematic because it's an attempt by the CEQ to let agencies off the hook when it comes to considering climate impacts. So if you want to build a new highway, the carbon emissions from actually building that highway, from having the construction equipment and all that out there building the highway, those are the direct impacts. And while those are important, those are only a small piece of the puzzle. So when you look at that highway, once it's been built, for decades to come, there's going to be a lot of truck traffic and a lot of cars driving on that road. And they're all also going to be emitting carbon dioxide. And that's really going to be the biggest piece of carbon emissions from that new highway. And under the proposed rule, the concern is that agencies would sort of take this as an excuse to not think about those sorts of impacts. and it would the rule would encourage agencies to ignore downstream impacts, which is especially problematic with climate change, because a lot of those impacts are more downstream, and climate change impacts also result from cumulative impacts. So, you know, a small amount of carbon emissions from one specific project might in its own not look that big or that important, but when you combine it with all of the other carbon, dioxide and greenhouse gas emissions, that's when you really start to have a problem with climate change. So the second broad category is that the rules would undermine the limited review that would still be required under the proposed rules. So, for example, under the current regulations, a project proponent, so whoever wants to build a project, is barred from doing the NEPA analysis themselves. So how this plays out in practice is that a project proponent, whether it's a private company or a state agency or a federal agency, that project proponent will often hire a consulting firm to do the environmental review. And then the federal agency, which is under their actual requirements from NEPA, has to oversee that review process and make sure that it's done well and independently confirm that it's all accurate. The proposed rule would let the project proponent themselves carry out the environmental review. So if a company wants to build a pipeline, they would be able to do their own review of the environmental impacts of that pipeline. Or they can hire a company to do it, even if that company has a financial stake in that pipeline being built. So this obviously creates a problematic fox guarding the henhouse type situation. The rule also states that agencies don't have to do any new research for the environmental review, but can just rely on, quote, reliable existing data. The problem is, anytime you have a new project proposed, you're going to need to do on-the-ground surveys and studies to see what natural resources are there and how they will be impacted. If you let agencies off the hook and say no new research is necessary, that really encourages them to rely on, you know, a desktop review. And the problem is that existing data is important, but our experience has shown that what agencies consider to be reliable existing data is often quite outdated or incomplete and not very reliable at all. Finally, the rules would also let the project proponent, again, that's the company that wants to build a pipeline, or, you know, the state agency that wants to build a highway, the rules would let that project proponent start buying up land and equipment to carry out the project before the NEPA process has even been completed. So the whole purpose of NEPA is to require federal agencies to fully examine impacts and alternatives before there's any sort of commitment of resources to build a project. So if you start letting people buy up land and equipment before the environmental review process has even been complete, that undermines the whole purpose of NEPA. So the last category that I want to talk about is that the rules would try to limit public input and review by the courts. So first, the rule would limit input from the public and even from other agencies. So under the current rules, agencies have to not only read and consider public comments, but they actually have to affirmatively respond to public comments. So they have to say, well, Openlands and ELPC said, we didn't adequately consider impacts to grassland birds, and here's where we actually did consider those impacts. Or here's where, in the final environmental impact statement, we took those comments and we added a new section that does, you know, consider those impacts. Under the proposed rule, the agency just has to summarize public comments and then can certify that they considered them. So essentially that's just the agency saying, here's a summary of the comments, and yes, we really did think about them really hard, we promise. And so, I mean, taking an agency's, you have much more certainty that the agency is really considering those comments when it actually has to respond to those comments. And then if the public doesn't agree with how those comments were summarized, the rules say that the public would have to object to that summary within 30 days, or that argument would be deemed forfeited. The rule even goes so far as to limit comments from other agencies. So it says that agencies can only submit comments within their own jurisdiction or special expertise. So if an agency thinks that an environmental review is ignoring impacts to bald eagles from a new transmission line. But that agency that has this concern isn't itself in charge of protecting bald eagles. That's not its own statutory mandate. The agency would be prohibited from raising those concerns, which is sort of a nonsensical way of just trying to roll back and limit the NEPA process as much as possible. Finally, the rule also tries to interfere with review by courts, which really reaches far beyond what an agency like CEQ has the legal power to do in a rulemaking. So on the last slide, we talked about how an agency could just self-certify that it considered public comments. The rules say that this would create a conclusive presumption that the agency really did consider those comments and consider them adequately. The thing is, if somebody brings a lawsuit challenging an agency's action with NEPA, it's the court that gets to decide if NEPA was followed or not. The agency doesn't get to create a presumption in its own favor or in the favor of other federal agencies that NEPA really was complied with. Similarly, the rule has this provision where if arguments aren't raised within 30 days of the summary process, which is a whole new process that CEQ sort of just created out of whole cloth, the agency says that those certain arguments would be forfeited if not raised within 30 days. Again, that's not a question that an agency can decide on its own. Whether or not arguments get forfeited is something for the court to decide when it's doing its review of the agency decision making. Finally, the rule states that it is CEQ's intent that minor errors do not invalidate an agency action. Again, this is a question for a reviewing court to decide, not something that an agency can sort of on its own decide. So that's an overview of some of the major concerns with the proposed rule. In terms of the process and what's coming next, so CEQ held 2 public comments on public hearings on the proposed rule. So these were hearings where members of the public could go up in front of CEQ staff and say, you know, here's our thoughts and feedback on the rules. There were only 2 public hearings. One was in Denver and one was in DC. Usually in a rulemaking of this size and complexity and importance, there would be a lot more public hearings than just 2, and they would be a lot more across the country in different regions. So we requested that there be a public hearing held in the Midwest, and that was just sort of ignored by CEQ. And the other piece about the public hearings is that you had to sign up beforehand using Eventbrite to have a spot to talk at the hearing. And the spots were very limited and actually sold out on Eventbrite within minutes of going live. So I actually tried to snag a spot in DC for that hearing, and I was refreshing and refreshing and refreshing the page, clicked on it as soon as it went live, and was not able to get a seat because everything went so fast. So that really sort of just highlights how important this rulemaking is and how many people are concerned about it. And the CEQ did not provide opportunities for everyone who wanted to provide comments in person to do so. They did accept written comments. So Openlands and ELPC and tons of other organizations provided comments. So that written comment period closed on March 10th. The next step is that CEQ will hopefully consider comments that were submitted and then craft a final rule. Because of the COVID pandemic, the latest that I've heard is that the final rule is probably expected sometime in the fall. Given the Trump administration's track record, I would expect that the final rule would be fairly similar to the proposed rule. In other words, we expect that the final rule will be very, very bad. And after that, it's likely that a number of environmental organizations would bring lawsuits to challenge the final rule under the Administrative Procedure Act, essentially arguing that CEQ's, the CEQ in promulgating this rule was unreasonable. So you might wonder sort of what happens with the final rule when people bring challenges in court, whether that final rule still goes into effect. And the answer is the rule would go into effect, but the organizations who challenge the rule in court could ask the court to put a stay and make it so that rule doesn't actually go into effect while that litigation is pending. So the court may or may not do that. And even if the rule does go into effect, there's an interesting question about how much the courts would defer to the rule if and when it conflicts with established case law about what NEPA requires. So there's decades of case law, so opinions issued by courts about what NEPA requires. And if that case law is inconsistent, or if this new rule says you don't have to do X, Y, and Z, but all the cases have said and all the courts have said in their opinions you do have to do X, Y, and Z, there'll be an interesting question there about how that plays out as well. A final consideration that I just want to note is the 2020 election. So if we have a Democrat win the presidency, we might expect to see some efforts to withdraw or walk back some of these Trump's rollbacks. So we'll just have to wait and see how that all plays out. With that, do we have any questions?
Great. So there were a few in the chat box. Well, just one. Does the Skeletal Protection Act that you mentioned, Stacy, include Native American burial areas? And everybody should feel free to add questions to the group chat. You can also, you can raise your hand as well, and then *6 if you're on the phone, and we can unmute you. So, but do you want to answer that question about the Skeletal Protection Act?
Sure. My understanding is yes, and in fact, it influenced the path of the Ileana Tollway. Practicable on us to all be involved to point out the things that are wrong in these truncated reviews. And for those of us that do have the potential to really seriously consider whether or not to challenge those in court in order to demonstrate why these rollbacks have a tremendous effect on us all and what we care about. You know, there are going to be points of litigation. There are also points where we all just have to basically, as Howard would put it, put this into the court of public opinion and really be very vocal with decision makers on all levels as how this is gutting really core central protections to public health and well-being, so that it doesn't just die on the vine, that it is kept alive and well, and people are really understanding as this plays out how bad this is and why it needs to be changed. Ultimately, hopefully, we'll be able to repair this as things swing, as they always do in our country, and we can reinstate these protections as well as many others again. We'll need you there too.
Thanks, Stacy. I want to ask a question, and then there are a few more that are in here, but I want to ask this just because I feel like our members bring this up a lot. You know, you brought up environmental impact statements as part of an important part of NEPA. There are a number of states that have EIS statements, EIS procedures. Illinois is not one of them. Can you elaborate on like what state EISs are like, and I guess just underline that Illinois doesn't have that process?
So I think probably both of us are going to want to answer this. It would be valuable to have state protections in place. It is possible, just like the Clean Water Act, to have state level protections and processes which would provide the same kind of review of many of the things that we care about. Generally, those review processes are combined and run parallel to one another in other states. It is a procedural rule, and some of these processes are both federal and state. Some of them are only federal. So to have a state process govern federal review, there are parts where we can do that and parts where there will be deference.
Yeah, so I've been working recently on a proposed transmission line project in Wisconsin. And Wisconsin is one of those states that has a Wisconsin Environmental Policy Act, which is modeled very closely on NEPA. So there are a handful of states out there that have their own what are called little NEPAs, or state versions of NEPA. And most, or a number of them at least, the ones I've come across are fairly similar in structure and the process to NEPA, where they have a scoping process and then they have a draft environmental impact statement if it reaches that level of review, and then there's a public comment period, and then a final environmental impact statement, except that it applies in more situation or different situations when it's a state agency that is taking an action or you know, funding something. In the specific case that I've been involved in Wisconsin, the two processes, the state and the federal level environmental review processes, were not combined, and they were actually carried out separately. So we had a separate state level environmental impact statement and then also a federal environmental impact statement, and they were done on different timelines. They've both now been complete, but it's interesting because it gives us sort of two different bites at the apple, where we can now challenge it on the state side and the federal side. And there were some common problems with the way that those EISs were done, but there were also some differences in the way the state versus the federal carried it out, which offered different vulnerabilities when it comes to litigation.
Great, thank you. So there's a couple more questions in here. From Arlene, to what extent could challenges be brought to specific projects once the final rule is adopted, if it is changed much from the proposed rule?
So if the final rule is adopted and it is changed from the proposed rule, it would sort of depend on what that final rule looks like. And I'm not sure if the question is actually if the final rule isn't changed much. And it'll depend, I mean, it'll depend on what the final rule looks like. One of the questions, I think if the final rule is finalized in a very similar form to what the proposed rule is, I think it will be pretty vulnerable to challenges to that rule itself. And, you know, if the final rule were to be similar to the proposed rule and were to be upheld when it's challenged in court, that would certainly require us to do some thinking about how we bring challenges to specific projects under NEPA. There, you know, and part of this would have to do with to what extent courts would actually defer to CEQ's rules versus continuing to follow the existing case law, which has been built up over decades and is quite strong in some federal circuits. So it might require some creative thinking about how to bring NEPA cases if the final rule were to look like the proposed rule and was also to be upheld in court.
Well, let's do one last question, kind of combining the last two. Just somebody asked about the role of senators or Congress to weigh in and have an impact, but also are there any challenges being brought to the fact that there's a pandemic going on to require the decision to be postponed?
My understanding is, since all of the public hearings have been held and the public comment period has closed, that COVID-19 isn't coming into play as far as public participation, and that the agencies are moving along whatever timelines they can to produce this. I don't know, Rachel, if you have any other, I know that some agencies have prolonged timelines on certain things a little bit, but I haven't heard anything about this one.
Yeah, I think that initially the final rule was expected sometime over the summer, and it's now looking likely like it will be more like in the fall. But that's just sort of about CEQ's own timeline for finalizing it rather than a challenge based on COVID. I mean, like Stacy said, because the actual public hearings and the public input section has already run, and that all occurred before the COVID-19 issue, I think there's less of a hook for this specific rulemaking, but that's certainly something that we should be thinking about in other contexts and other environmental things that, you know, Trump's sort of trying to shove through a lot of things right now when people are very busy and distracted with COVID-19. And it's important that we sort of keep an eye on what is happening and step up and bring challenges when we can.
So I think with the senators and congressmen, the last question, keep us alive with them. You know, some of the stuff like WOTUS, there is a question as to whether or not this needs to be fixed once and for all by statute, or whether or not we just want to keep playing ping pong with the regulations. And that's, you know, a policy question moving forward that I think we all need to really seriously evaluate and determine whether or not, if as things eventually shift, we want to bring proposals for legislation forward in Congress.
Great, thank you. And so, again, thanks for joining. And we'll conclude it here. If you're an attorney, please make sure to fill out the CLE or email me if you did not get it in the chat box from the Zoom. You know, Rachel is from Environmental Law and Policy Center. Stacy is from Openlands. Somebody asked if you could follow them on Twitter for updates. And I think ELPC is ELP Center. And Openlands is just Openlands, right?
Yes.
Yep, you can follow them. You can follow IEC at ILEnviro. There, I saw some of you tweeting about this already, so I really appreciate that. But just again, thank you for joining. We really hope these sessions will help keep us connected. This is a really difficult time. We're making these publicly available, so we're going to follow up. We have a YouTube playlist that has all of them. We usually get them up within a day or so you can watch old ones, watch new ones. Giving you a lot of content. And we have decided to extend this series until the 30th, which is the end of the shelter-in-place order that has been renewed. And we're just going to keep going. We have a lot of people in our community that want to present, and we're going to keep going. So if you're not already a member of IEC and you're able to give, please consider joining today by using the link that Jeff put in the chat box. Again, please fill out your CLE. Tomorrow we also have a thing that we've applied for CLE tomorrow that's on clean energy procurement with legal counsel of the Illinois Power Agency, Brian Granneman. We've applied for CLE for that one as well, and I do hope that you will join us for more of these. Thanks everybody for being on and having lunch with us, and especially thanks to Stacy and Rachel. Guys, have a great day. Thank you so much for being on.
Yep, thanks everyone.
Bye.
Thank
Bye,
you.
everybody.